considered the motions and the responses, and without elaborating further, lest my words be used against me later, I'm going to overrule the motion. I'm not going to grant a new trial this matter. Prepared to go to sentencing at this time?
Yes, sir.
Yes, sir. All right. As I stated earlier, I have received the pre-sentence investigation report and reviewed them. Have the defense attorney been able to review the pre-sentence investigation reports?
Yes, sir.
Any additions or deletions to information here?
Only that's set forth in our sentencing memorandum.
Let me start with Mr. Sittenberg on behalf of Mrs. Dreamer. Would you like to address court litigation?
Thank you, Your Honor. Mrs. Dreamer?
Yes, I do.
Judge, I have submitted, I think it's a 14-page brief sentencing memorandum that goes through all the factors that the court must consider with respect to sentencing Mrs. Dreamer in this matter, Judge. I'm not going to reiterate that. I'd like to incorporate that by reference, Judge, but just briefly touch upon it, Judge. When you look, and we're all familiar with what the factors are, Judge, and I would respectfully submit to the court that with respect to those factors that are set forth in 2929-12D, which talks about recidivism, Judge, none of the factors suggesting that recidivism is likely weigh against Mrs. Dreamer. And all of the factors, Judge, that suggest that recidivism is unlikely weigh in her favor. With respect to the seriousness factors of 2929-12B, Judge, and there are 9 of them for the court to review with respect to whether or not this offense is more serious. It's our position, Judge, that none of those apply. And when taking into consideration and balance against those factors that must be considered as to whether or not Mrs. Dreamer's conduct was less serious, we would forward as she was convicted of in this case, Judge. And there are 9 factors, Judge. We would respectfully submit that none of those suggest that anything other than community control sanctions are appropriate in this case. Judge, you heard the evidence in this case, and we respect the jury's decision, but I think it speaks volumes that must be considered with respect to this court passing judgment on Mrs. Dreamer. Those counts in which she was charged with willful conduct, the jury returned verdicts of not guilty. The 2 counts in which she was convicted, Judge, reflect negligent misconduct on her part. And we would suggest that the state of mind being much less egregious than would be in a willfulness go to and weigh in her favor with respect to whether or not community control sanctions are applicable, Judge. You're not minimizing the fact that the election laws were violated in this case, Judge. Unfortunately, or fortunately, depending upon your perspective, there are no other convictions that we're aware of or we've been able to find for those statutes for which Mrs. Dreamer has been convicted of. So we can't look to that. But we have to take out of the context that we have all these television cameras and all the people looking at this, and we would suggest just look to the factors that the statutes require the court to look at. I spoke with Mr. Baxter briefly before the sentencing today, and Mr. Baxter articulated for me, and I'm sure he'll articulate to the court, that he is going to suggest that a term of incarceration is appropriate. If he does, Judge, I would like the opportunity, before the court passes judgment, to address Mr. Baxter's remarks. In particular, I'd like to know what factors he is suggesting support a term of incarceration. Mrs. Dreamer is a 40-year-old lady. She is paid dearly already by public humiliation and by the loss of her job, Judge, already. I don't know what factors would suggest that Mrs. Dreamer should, a message should be sent out that she should be incarcerated for her conduct. After all, Judge, we're looking at a 4th-degree felony and a 1st-degree misdemeanor, and I would only ask the court keep it in the proper context with respect to the remarks of Mr. Baxter. If he is to suggest that there's an ongoing sentencing factors that we've addressed, Judge, I would suggest that that argument holds no weight, because in fact it weighs against the term of incarceration. He's made public his remarks that she's granted immunity to these defendants if they were to cooperate in his investigation. And as the court is aware, Mrs. Dreamer gave a 6-page statement detailing her involvement in an attempt to offer a proffer to the state, and they rejected it out of hand for whatever reasons. But I think to punish her for failing to cooperate at this point in time, as I think the state might suggest, does not fall under the sentencing factors and is not an appropriate factor to take into consideration. So I would respectfully request that a modest term of community control sanctions, given Mrs. Dreamer's lack of place in a position where she can reoffend, is absolutely zero, given the fact that she's no longer in her position. And I think, Judge, that those people who stand in the position that Mrs. Dreamer stood in while she was an employee of the Board of Elections heard loud and clear the seriousness of any kind of misconduct, as well as the possibility of any sanctions being imposed for people who are Board of Elections employees by losing your job and having your name dragged through the papers. I think is enough of a deterrent that an additional period of incarceration is not only unnecessary, but would be far too punitive for the situation. So we're, again, not to reiterate, but we're hoping that a modest period of community control sanctions will be the sentence that this court deems to be appropriate in this case. Thank you very much.
Mr. Sonnenberg, did your client's statement to the state of Ohio include where she received any direction, or who else had knowledge with respect to her actions in that recount?
It did.
Anything else?
No, thank you.
All right, Mr. Dreamer, what would you like to tell the court?
I'm not a very good speaker, so the past 19 months of my life have been unimaginable. I went to work one day, did my job, and this is what happened. Hopefully, with this happening, it has good, and that is that other people in other boards of elections will have more knowledge of the code they're to follow because of everything at that. And, you know, I just think that, you know, it should be for other people out there that, you know, something good has to come of this. And I'm just asking that I be able to go home with my family.
Mr. Dreamer, do you feel like you've given the state of Ohio all the information that you have, all the other people who had knowledge of what you did, all the other people who may have given you direction with respect to how that recount was
Yeah.
provided? You've given all the information that you have available to the state of Ohio.
Yes. I was not included in every meeting at the Board of Elections. And it's been asked of me, and, you know, whether I know, and, you know, this big conspiracy, it's not there. I don't have it. I don't need to protect anybody. I need to protect myself. And I can't give you, for the prosecutor, what I don't have. I was truthful with him in the beginning when I met with them originally. I was truthful with them in that statement that I gave them, and to have them call me a liar and then even give me a lie detector test is terrible. And I did give them every bit of information that I had, to my knowledge, that I had. Anything that I knew, I told them. I have nothing to hide.
All right, let me hear from Mr. Rotatori on behalf of Ms. Nate.
Judge, during the course of the trial, we had an opportunity to watch the court sentence individuals during breaks and recesses, handle probation violations, quite a few during the course of the trial. And we got observed destruction of property, anything like that? Absolutely not. Is Jackie Maiden need to be incarcerated to send out a message with regard to the violation of law she was convicted of? And I think not, Your Honor. She did her job as she understood it to be. Now, the jury has said in true failure to act and negligently acting that it was wrong. And we have considered that. Jackie's been fired. She's been fired at a point where it's going to affect, obviously, her pension as a public servant. It's going to affect her medical coverage as a public servant. So she's paying dearly. Jackie's very active in this community, serves the community, gave the court letters from people within her community. She's an asset to this community. She's not a threat to this community. She's an absolute asset, Your Honor. And we ask that Your Honor impose a community control. Now, I'm hearing from the other questions that were directed to the other defendant. I can tell you that Jackie Maiden gave several statements during the investigation by the special prosecutor and during the pretrial process. She gave another statement under oath. And she's cooperated in every respect. And I want the court to know that. She didn't thumb her nose at the investigation. When she was called to be someplace, she was. When she was called upon to produce certain materials, she did. And it's just that again, in all honesty, the prosecution feels she's withholding evidence. And she's not, Your Honor. We've offered to have her take a lie detector.
All right, Ms. Maiden, I want you to tell the court.
Yeah, I am sorry for the embarrassment that this has caused. This whole incident has been an embarrassment to myself, my husband, my children, my grandchildren, the rest of my family at the Board of Elections, my co-workers. It's been an embarrassment to them. It's also been an embarrassment to the memory of my parents and my grandparents who couldn't go. So I did not take my job lightly. I never did. And I was working, I always worked diligently. In my 20 years at the board, I've always tried to do my work in a way that people that work with me would be proud to say that they work with me. I've never tried to do anything underhanded or intentionally tried to do anything illegal. That was not only at the Board of Elections, that's just my lifestyle. And this is also, I have forgot, this is also embarrassing to my church family. I don't know if I said that, because I'm very involved in the church. And my husband's a pastor. And so my lifestyle is not one of intentionally doing things illegal. I tried to help Mr. Baxter every time he needed help, even when we had to speak with him without the benefit of our own attorneys. And I was always honest and open. So I'm sorry for any embarrassment that this has caused. And I do ask for an
Ms. Maiden, at whose direction, or whose idea was it to pre-count the ballots, check them against the official count, and then switch out precincts that didn't add up?
Your Honor, as I explained to Mr. Baxter prior, this was a process that was going on prior to my even working at the Board of Elections.
Pre-counting,
Since 1991.
checking the
Yes,
official, unofficial
Yes.
count,
yes, sir.
switching out precincts that didn't add up?
I never knew about switching out precincts.
Well, whose idea was that?
I can't tell you that, I don't know.
Well, you were the manager in charge here that day. Was it Mr. Santora's idea himself, or Mr. Sinnenberg's relative, Mr. Macular? Did they just do that themselves?
I cannot say. I was the administrator, I was not the manager.
So you're unaware that that was happening, a wrong thing to do?
We've never switched out precincts.
You're not saying it didn't happen this time?
Well, obviously, the court had said it did. I said that when my statement, I said that I was not aware that it had happened. And that was the statement that I gave. You know, lying is not a lifestyle. That's not the way we live.
Your Honor, what happened here was reprehensible. I mean, the evidence was overwhelming that there was a recount that was rigged here. What's more troubling, it wasn't anything more troubling, or more sad in this case, is again, from the state's perspective, that these defendants have never come clean, have never admitted what's been going on. Now, Ms. Dreamer and Ms. May referred to conversations that we had. Just for the record, once again, when I got in this case, one of the first things that I did, besides reading the memorandum from Reno outlining this case, were to met with these ladies. I will represent to this court that they never said anything about any precincts being swapped out, anything being compared for purposes of substituting precincts for those that balance with the poll books or with the official count. In fact, Ms. Dreamer was visibly upset that even someone would even make such an allegation. So we continued on. We presented this case to a grand jury because at that particular time, it became apparent that there was at least some inconsistencies, or at least some people that weren't becoming truthful or coming clean in this investigation. We spent two and a half days in grand jury. 15 witnesses in grand jury. They were subpoenaed, they didn't testify. The ink wasn't dry on the indictments on August 30th when the Board of Elections, under the supervision of Chairman Bob Bennett, issues a press release saying we are confident that no employee of the Board of Elections would knowingly or negligently engage in any unlawful conduct regarding the 2004 presidential recount. We as board members unanimously stand by our employees in the face of these allegations. The board then, after Ms. Maiden was later indicted, the board then issues another statement saying the investigation must stop. Then just a couple weeks ago, Bob Bennett happens to be in the Sandusky area, speaking to the Republican Party there, and he calls these convictions a travesty of justice. He says that they did nothing wrong. He believes they'll be eventually overturned. Now, when you look at that, what I would say is vigorous and amazing support from a public body of people who were indicted by a grand jury and now convicted by a jury of violations of election law, felony violations. It's amazing. It's astounding. And then you look at what the state believes is not coming clean these people as to what happened and who was involved, and more precisely, who instructed them to partake in this. Let's talk about that. We have two different proffers that you talk to the people about.
Ron, may we approach?
Jack.
May we approach?
Sure. Objections overruled. Mr. Baxter, you may continue.
Once again, Ms. Dreamer in her proffer states that she was instructed by Ms. Maiden to discard ballots that didn't, or precincts that didn't balance with the poll books. Meanwhile,
Ms. Maiden, as she stated here, and in her proffer, saying that she didn't know anything about any, in fact, I'll read it. I am not aware that any precincts were discarded from the random sample because it did not balance with the poll books. I never instructed anyone to discard any precincts or to verify numbers for the poll books. This had never been practiced for the department. I did not believe that Kathy Dreamer or Rosie Greer discarded any precincts. And then Ms. Dreamer also says that she's not aware, either the sentencing or whatever, she says that she's not aware that any precincts were discarded or counted when we compared the official count, which was the second triage, if you will, to exclude and substitute and swap out certain precincts. Yet all the evidence, including Jim Santora, who testified to this court, says that they did that at the direction of the manager and the assistant manager, Kathy Dreamer and Rosie Greer. So, to suggest that these folks, these defendants, have been honest with the prosecution, or at least even consistent with what the overwhelming evidence is just not true. It just hasn't happened in this particular case. They violated a public trust. They were in a public position. They were there, like the Board of Elections, to protect the public, to maintain the integrity of the election process, which is vital to every component of our system, in our society. You know, Ms. Dreamer, in a number of her different places, in her sentencing memorandum, page 7, page 10, page 12, page 13, says she didn't know that this was wrong. She didn't know that this was illegal. She had no criminal intent, no knowledge of that this was illegal. Well, geez, we got her on December 13th, the DVD or video that was shown to the jury, where she was evasive, she and Miss Maiden were dishonest, they were hiding the ball, and Cyrus Taylor and Kathleen Wynn and Miss Lovegren, who were questioning about the process. Little did they know, we found out through the others in this case, that they were really in the process at that point in time of running this recount. Then later, on December 16th, Miss Maiden, at the official recount, when asked by Sarah Taylor, who took the stand and testified here, when asked, are the ballots as they came out of the machine? She said yes. She doesn't go into any of this recount, any of this 3-day process they went through. And in that video, in that DVD, at some point, Miss Dreamer is depicted there. She's present. She's listening to this. Later on, Miss Maiden appears at a couple board meetings. These are public meetings when the cat's out of the bag. When she's at those public meetings, and she says, first of all, we only looked at the total count. We were not looking at who won, who lost. But we know that's not true. We read the evidence. That's how they arrived at whether or not they were just going to discard or swap out certain precincts. And then later, at a subsequent meeting, when Mr. Taylor, the lawyer, Candace Hoke's husband, George Taylor, appeared at the meeting and said, we have information that 3 or 4 precincts, at least 3 precincts, were counted, were pre-counted, were pre-sorted. She then backs up and says, yeah, well, 3 or 4, but that's it. In her proffer, she says the same thing, 3 or 4, but no more. That was it. Well, we know that's not true. We know that all 34 precincts were counted. So, I mean, I think the court in the state is in a predicament, Your Honor. I mean, this is a sad case of these ladies, these defendants, having an opportunity after opportunity after opportunity after opportunity to simply tell the truth. Not only for the system, but also for themselves. And they have refused to do so. I mean, it's abundantly clear. So the question comes down to, and one of the criteria that Mr. Sinenberg cites in his sentencing memorandum, which is, of course, in the law, is that they're in a public position. They're holding a position of public trust. And not only did they violate that, reprehensibly so, but then they covered it up. And they concealed it. And I believe, Your Honor, the state should say the state Also, Mr. Sonnenberg indicates that under 29.12B, he identifies 9 factors in his sentencing memorandum, of which he maintains that none apply. We disagree. 3 says the offender held a public office or position, trust in the community, and the offense related to that office or position. Clearly that applies here. Clearly that applies to Mr. Stewart as well as Ms. Maynard. Number 4, the offender's obligation to elected office or profession obliged the offender to prevent the offense or bring others to justice. Certain things, manager, election coordinator, these defendants were obliged to maintain the integrity of the process of the election. They had a duty to maintain the laws incumbent upon them by the revised codes of the Secretary of State. That applies. And number 5, the offender's professional reputation or occupation of elected office or profession was used to facilitate the offense or was likely to cause future conduct. And certainly was used to facilitate the offense. They couldn't have done it unless they held these positions of trust, these public positions of trust. Also the fact, we talked about no restitution. What about the $14,360 to meet right there? They get a phony recount. They're out the money. I mean, restitution should be made somewhere along in this case. I don't know if it's apparent here. I'll leave that up to the court, but I think that's a point that sometimes defense counsel misses or doesn't elaborate. So, for those reasons, Your Honor, again, at first glance, you look at these ladies, you look at these defendants, community sanctions certainly seems to be something that's appropriate, but when I go through this process, what happened? And after the fact, it just seems tough to put them on community sanctions. It seems like if they're not honest now, how are they going to be honest during community sanctions? Something this court has to monitor. Is this how we want to start out, being on probation? So for all those reasons, Your Honor, I don't think community sanctions is appropriate. Certainly leave them for the court to get a sentence. I don't have any magic sense of this. This is a very difficult situation not only for the court, because I know you have to make a difficult decision. And I certainly don't envy you in that position. But it's also difficult for the state. I mean, it's not something that the state will ever want to pursue through to this point, but it comes a time when, in the face of what seems to be an obvious subterfuge or obvious concealment, there's no choice. So thank you.
All right, Mr. Sonnenberg,